resources in there, so a lot of the things that people are talking about, they're in the back of the journal, so you can check out those resources. So moving along with the theme of the Supplemental Needs Trust and Special Needs Trust, we have our friends from Plan New Jersey, a fantastic organization, and read about them. They have a table here. And Ellen and Nancy are going to talk about how to administer a special needs trust, because we've now created one. What do you do with it? What do you do if you're a trustee? Because they are trustees of a lot of these trusts. And the question we get all the time is, how do you pick the right trustee? Because we could talk to families, and the easy part is, hey guys, you need a supplemental needs trust, you need a special needs trust. And then they say, great, that sounds wonderful. And then you ask the hard question, who should be the trustee? And then all of a sudden, it creates other conversations. So those are the topics that are going to be addressed. I appreciate you being here. You guys are wonderful.
Thank you so much. Good morning. We really appreciate being asked to be here, and I'm going to start with one quick point of clarification. I'm Ellen, and she's Nancy. So we wanted to just give you a little bit of the inside scoop on what it's like to be a trustee of a special needs trust. And I guess we can move the slides here. How do we do this? Okay. Yeah, oh, thank you. It's better? All right. I'm gonna try. Might need some help still. It's not moving. Oh, is it? Oh, it's not here. Okay, sorry here. So you can a preview of everything we're talking about here. Okay. So Plan New Jersey is a statewide organization that serves people with disabilities. And we do serve as trustee of special needs trusts, guardian, legal guardian, and we do a number of other services that I'll tell you about briefly. But you may wonder why can a nonprofit organization serve in these capacities? And that is because we are established with enabling legislation called the New Jersey Community Trust Act. And that allows us to serve as trustees for those trusts that you talked about, you heard about first party and third party trusts. Nancy's going to talk more about those details. It also allows us to serve as legal guardian, as power of attorney. One person had asked us, actually an attorney had asked us, well, are you subject to banking regulations? And we're not. This other enabling legislation enables us to do what we do. So we are, as I mentioned, statewide. We serve all of New Jersey. The mission of our organization is to help answer the question, who will care for my loved one when I'm gone? So we do try to be a pretty comprehensive organization. We serve all different kinds of disability, people who have disabilities, people with a lot of support needs, people with a small number of support needs, whatever, where we consider ourselves a person-centered organization. We're trying to understand who is that individual, how much support do they need, what support do they need, and we try to individualize those services and supports to meet their needs. So, as I mentioned, we are trustee of special needs trusts. We do that in a big way. We have over 600 active special needs trusts. And we also have approximately 400 what we call future trusts, meaning there's about 400 families who said, have named us in their wills as successor trustee. So this may be that we're successor to multiple family members, or it may be that we are immediately, as soon as the families need us, we are going to be taking on that role, that responsibility. We also are legal guardian for about 40 people, a little more than 40 people. And in this case, we have been appointed by the courts to serve in this capacity. And I really do appreciate Dawn's comments about the importance of respecting people's rights and to self-determination. Guardianship does take away individuals' rights. And so we want to really be careful about determining what level of legal protection, if any, needs to be, well, not if any. We were told that everyone needs a power of attorney and a healthcare proxy. So we want to really be thinking, though, about there is kind of a pipeline to guardianship in school, especially in special ed. There's an assumption that, oh, if you have a disability, if you've got an IEP, if you've got a diagnosis, you need a guardian. That is not necessarily true. So we want to really be careful about respecting people's rights. Even under guardianship, we are required by law to honor people's self-determination, but we also want to really think about the type of guardianship or not guardianship, other alternatives, the conservatorship and those things that Don talked about. The other thing, we do serve as representative payee for special needs for Social Security benefits. And I want to mention, I think it was Sean who said that, there are components, essential components of an estate plan, a will, a power of attorney, and a living will. I want to add a fourth one that I think is essential, and that is what we call a life plan. So especially for a person who's got a significant disability, we need to very carefully describe on their behalf, if they're not able to do it for themselves or for them and for their parents, what support needs does the person need? What are the things, the things that they like, that they're good at? What are their medical needs? What are the doctors you would never go to again? All the different things. We want to look at all the domains of life and write those down so that there's a clear communication tool that communicates to future caregivers what the person needs and what the person doesn't need. So I just want to make a case. We do a lot of life planning with and for families, so we ask a lot of questions and write down a very detailed document. It's usually about 20 or 25 pages. It's kind of a biography of the individual to guide future caregivers. So the other thing we do is case management and advocacy in a pretty intensive way. So sometimes families say, we have people to manage the legal representation, the financial management, the trustee of special needs trust, but we want you to be eyes on the person. And so we do have staff who visit people, sometimes monthly, sometimes more often, in order to make sure that they are well cared for in their circumstances. And unfortunately, what we do know is that when people are visited, they get better care than if they're not visited. And so we do something called home visits. And so we'll move on to special needs trusts. And you heard really an excellent description of what a special needs trust is and why it's important to protect people's benefits. As I'm sure most of you know, that in order to qualify for Supplemental Security Income, SSI, or Medicaid, a person can have, in general, no more than $2,000 in assets. And that is a very, very small amount of money to have in savings of any kind. We do have the ABLE accounts that have helped, but not everybody qualifies. We look forward to, is it a year or two? 1 year when ABLE accounts will be available to people up to the age of 46. But right now, it can be challenging to qualify somebody for an ABLE account, but it's a wonderful tool for those who do qualify. So I'm going to turn this over to Nancy, who's going to talk about the role of the trustee and also a little bit about how you might choose a trustee. So it's a challenging and tricky task. Actually, I've got one more slide before that, and that is about, this is about pool trusts. So Don mentioned that administering a special needs trust is different depending on where the money came from. Did the money belong to the individual, which we typically refer to as a first-party trust, or did it belong to, or self-settled trust, or did it belong to a family member, or friend, parent, grandparent? Where did that money come from? And if it is a first-party trust, we have to be very, very mindful of especially the rules of Medicaid and SSI. And they are changing, they get changed, they get changed back recently, and so they can be very tricky. Thing that I wanted to just add to this mix is that while we've got these flavors of trusts, first party and third party, we also have a type of trust which is called a pool trust. So for many families, for most families, if you're doing your estate plan, you're gonna go to an attorney, and please do go to an expert attorney. We have families who've said to us, oh yeah, my family's attorney's gonna write this, and then it doesn't qualify, and then the person loses their Medicaid and SSI. We've seen that a number of times. But a pool trust is really very similar. It is a special needs trust. It's just that these tend to be smaller accounts, smaller amounts of money, and so we can pool them for investment and management purposes. And so every individual who's a participant in the pool has their own account, their own sub-account. It's separately accounted for, separately managed. When we make a distribution to buy a television or a computer or clothing or whatever it is, it gets accounted for in their sub-account, but everyone gets a piece of the investments. And when you have a large pool, then you benefit from the ability to invest. Whereas a tiny amount of money, it's hard to invest and the fees are very high. So from an investment standpoint. So only a nonprofit organization can hold a pool trust. So we have what's called the Plan New Jersey Community Trust. And those trusts can be funded with a minimum of $25,000. So it's very often used when there's a very small settlement, or when somebody comes into a small inheritance, and maybe they didn't do the right planning, but they need something, because even $25,000, anything over $2,000 will cause them to lose their SSI and Medicaid until it's spent down. So the pool trust is a real value. The other feature of a pool trust from the nonprofit side is that most of the pool trusts that we operate are first-party trusts. We definitely have third-party trusts in the pool. But for the first-party trusts, as it was mentioned, there's a payback to Medicaid. And so most of the time, all the money will go back to Medicaid to reimburse Medicaid, rightfully so, for the benefits that the person has had, the medical benefits that they've received. However, in the case of a pool trust, in our case, 50% is retained after the person passes away, and that money can be used to benefit people with disabilities. And we have used it. It has come in very, very handy for us. For example, unfortunately, one of the challenges with Medicaid is if you don't plan for your own funeral, and you don't have the money for a funeral, and you pass away, you can't use your trust for the funeral costs. So we have purchased quite a few funerals with this money. We also use the money to provide pro bono services. So there are some people who need a guardian and they don't have the funds to support a guardianship representation. And so we have about, I think it's 8 or 9 pro bono guardian clients. We do a lot of our social services, the home visit monitoring that we're able to do with both grants that we write and the benefits of the remainder beneficiaries from the remainder of the pool trust. So I'm going to turn it over to Nancy, who's going to talk to you about the duties of a trustee.
Well, good morning. Let me start by asking, do we have any other trustees or trustees organizations here today? 1, 2, some kindred souls. Welcome. I going to start also by saying that doing trust administration is not for the weak at heart. And those who do it in this room will agree to that. Once the trust is funded, the dance begins. And you, as a trustee, have quite a bit of duties. You do not always wear the same hat, so we don't always just wear the financial hat. There are days when we have to wear the case management hat, therapist hat. Sometimes we also wear a little bit of an accountant's hat, but you have to be flexible. It's not just about paying or, paying a bill for a client or purchasing something from the trust. With that being said, there are certain duties that trustees also need to be on top of. For example, you have to administer that trust in accordance with that trust document. You have to review it, and you don't just review it at the beginning of the administration. Really, you should review it annually. We have a lot of trusts. It's impossible for me to remember every single trust document that we have. So we do need to refer back. Most of the time, the terms of the trust, especially for self-settled trusts, are pretty similar because they have to follow the law, just the same, but they also have to follow and comply with regulations for Social Security, Medicaid, etc. But sometimes you see certain things that may not be correct. I have had trust on my way. When I look at it, I go, I'm not an attorney, therefore I cannot give legal advice. I will pick up the phone, call that family, and ask them to speak to their attorneys because we have had trusts that have had third-party trusts, actually we're mentioning that, will have language that actually has a payback to Medicaid. And we know, as I said, I'm not an attorney, but we know that's not the right way to have that language, so if families are not aware. So you do need to review that on an annual basis. And there may be some other terms of the trust that you don't feel comfortable following as a trustee. And the best approach is to be honest with the family, with the client, with the attorney that's hoping to have them move to somewhere else. Maintaining records. You have a responsibility and a duty for transparency. Whether that is to your client, successor beneficiaries in a third-party trust, or in a self-settled trust or first-party trust to state agencies, you also have to maintain clear records, keep receipts, have a good accounting of why you made that distribution. They're going to be looking, especially for first-party trusts. Excuse me. They are going to be reviewing. A lot of times, believe it or not, we get the most questions from local offices. Families or clients who go for their annual review or redetermination, and the state will ask to see a transaction report. They will want to see copies of checks, receipts, any quotes, invoices. You as a trustee need to be prepared to provide that information. You have to report annually also to the state of New Jersey Medicaid program in two ways. You do it to the legal and regulatory office of Medicaid, and you do it to the local office when your client goes for that redetermination. So be prepared, again, to have the document in the backup. Also, New Jersey has certain stipulations in trust that may not be the same in other states. For example, here in New Jersey, we do have to notify that legal and regulatory office of Medicaid if the trustee is making a distribution that is $5,000 or higher. And they will review that, and provide you usually with what they call a letter of no objection. Sometimes it's a letter of objection. And again, your duty is to present a case as to why this distribution needs to happen for this particular client. No self-dealing, major one. Plan New Jersey got a case about a few years back. It was a beneficiary who had resided in a nursing home facility for many years. Mom was a trustee. This was a self-settled trust. Mom was elderly at the time, and a nephew apparently approached the mom to provide his assistance. He became the power of attorney for mom, and indirectly also assisting mom in the administration of the trust. Mom starts developing dementia. It's decided that this is going to go to court, get a guardianship for her disabled son. It goes to court, and of course, as part of the proceeding, the judge requests to see an accounting. They provide the account, they provide the request to the nephew several times, and he did not come up with the accounting. There's always a delay, some excuse. The last straw is the actual attorney that was representing the nephew quit. He didn't want to be involved anymore. Big red flag. An attorney that we work with here in New Jersey approached us to see if we would be interested in serving. He was appointing guardian ad litem for the individual. He pushes the bank to provide accounting of the distributions because apparently his nephew had been going to the bank and taking out money from this trust. Not only was he doing that, but this trust had what is called a structured settlement. So he was receiving monthly deposits of about $5,000, which were then being taken to the bank, and then the nephew going after and taking out cash. When they finally reviewed those distributions, they were, now mind you, remember my beneficiary is a nursing facility. There were distributions for purchases of equipment at Home Depot, 3 vehicles, dinners at a pop of about $200 to $300. So there were all these distributions that had nothing to do with that beneficiary. This case actually escalated to an FBI investigation, but that is just an example as to why that transparency is so important and why you have to be careful when you're selecting a trustee as well. Comply with the Prudent Investors Act. We are not financial managers. That's not what we do. But we do have a responsibility in regards to that money. Even when you have a financial manager doing the investment for your trust, you still have the ultimate responsibility of oversight. You need to educate yourself with finances. You don't have to become a financial manager, but you do need to be familiar and understand what is actually happening with that money. You also, if you're a corporate trustee, professional trustee, you should have an investment policy. This is good not only for the investment managers that are helping you, but also for your families, your clients, to know this is what we accept and this is not what we accept. We're not going to have all of our investments in gold. Well, maybe lately it's not such a bad idea. But you need to be able to provide that information to your clients. Loyalty. Your loyalty as a trustee is to that client. No one else. You don't care about the successor beneficiaries. even if it's the state of New Jersey. But if your plan needs something, you need to fight to provide that to that beneficiary. You also have to be mindful that your client can be easily exposed to exploitation. So if you become familiar with your client's patterns, let's say somebody who lives alone, the trustees typically making distributions, you purchasing household items for that client, seems pretty typical, and all of a sudden those requests change. Now they're asking for, instead of 1 pack of roll of paper towels, they're asking for 3 packs of rolls of paper towel. Ask why. Ask the reason. A lot of times we laugh because we say they're crooks, there should not even be crooks, because we have clients who have called our office and we can hear people in the background actually directing them to ask for a particular disbursement. So knowing your client, and if you're in doubt, get a case manager. Get somebody to go out there and do an assessment. Listen, a lot of times when my bills ring, it's for a reason. And every time that you ignore them is when you get in trouble. So follow your instincts. And of course, you have a duty to pay taxes. You know, I always say that the IRS never loses. The same thing here. You have to report on the income that is generated by that trust. Now, trustee challenges. These challenges come with the administration and sometimes even before the administration. I want to take just a quick moment to ask you to clear your minds and forget who you are, whether you're an attorney, a financial manager, family member, case manager. And now I'm going to take you and step you into the shoes of a trustee. You're coming in the morning, you're all cheery, it's nice outside, good day, have my cup of coffee, check my emails, check my voice messages, nothing unusual. Some requests for distributions, nothing. Phone rings. You pick it up. First thing you hear is, how can I get my money? My son is turning 21. I want to get him a Rolex, $5,500. But there's so many things wrong with that request. You can't say there's so many things wrong with that request. So you try to be kind and, professional and explain the reasons why we cannot do that. Oh, wait a minute, that's not what my attorney told me. She said I could get any money that I wanted out of that trust. It's my money. Why are you telling me that I cannot have it? I'm going to report the attorney. I'm going to sue you. Well, that cheery smile just went out the window. So having communication with your client and with those parties involved from the beginning is extremely important. Have a meeting where everyone is involved. So when you're explaining your policies, your procedures, the rules for the programs like SSI, Medicaid, housing, everybody's on board. They understand. And follow up with your client in writing, provide them with something. Having one person that they communicate with in your office, it's also a good idea. Because not only for them, it provides stability. A lot of our clients are not too good with changes, but also for your trust, or your trustee in that office, or your trust administrator. Explaining the public benefits rules. There are many of them, and not easy to understand. They change, as I mentioned. We just had a major change happen in September of 2024 to the SSI calculations for income supported maintenance, which is used to be food and shelter. So it is important for you to review in detail know what your client's programs are, what benefits they're receiving, and then review those rules from the beginning. Advocacy. You need to be an advocate for your trust and for your client. And that may not always be about finances. Sometimes it involves somebody being evicted and they require your help. Sometimes it involves education matters. So we will help them find the appropriate assistance through an attorney. So this is also part of that administration, and it's not just a financial action. We should also be knowledgeable about benefits. Anything also related to your client, disabilities. You know, one word, for example, that always comes up is I have a lot of clients with traumatic brain injury. And as we talked about before, one of the things that we need to do is keep good records. We rely on a lot of times on clients and families to provide receipts if they're looking for a reimbursement, especially family members, or to send us a quote. We'll be able to discuss this with your clients, find ways to help them. It may not be easy for them to save that receipt every single month and send it to you. So maybe they can take a picture of it and send it over. So find ways to work with them in assisting. And again, you know, we spoke a little bit about this, but be alert to potential abuse, neglect, and exploitation. And have someone visit. You want to make sure that you bought that, 60-inch TV for your client and he or she has it. Hire professionals to help you with investments as well as taxes. There's a slide here with a little bit of giving you an idea of what some of the trust distributions that can be made from the special needs trust. I'm not going to go through them. I think we're going to be kind on the front. If you can take a quick glance. Selecting a trustee. When we speak to families, one of the major things or major questions that come up is the.
Nancy, I do have a question, because I know I'm
Yes.
distributions. Because I'm a trustee of a number of trusts as well.
Okay.
And I know you say you don't know what to expect, and the challenge is to deal with individuals. So the trust is supposed to be for the sole benefit of that beneficiary. And one of the challenges that I've seen is that sometimes the trust is funded with a personal injury settlement, maybe to a family without many means. And there is this struggle between this beneficiary who has needs that has now come into a fairly large sum of money, and a family that's struggling for housing and paying their bills. How do you manage and balance? Because the state is on this all the time. The child needs someplace to live, and the parents may not necessarily be contributing to the household and some of the obligations they have to raise a child. How do you balance that issue between making sure that the child is safe in an appropriate housing arrangement, but also understanding that the state is going to restrict you from using the money to benefit the other family members that are expected to support and raise their own child? And I find that to be a struggle that is very difficult to resolve. And it could be a simple question that I got is you're buying a handicap accessible van, and the state wants to make sure other people are not using that vehicle for their own personal needs. Aside from the housing, do you need a 2-bedroom apartment, a 3-bedroom apartment? Why are you allowed to pay for what you're not? No, we're limited on time, but I see that as a real big struggle in administration.
It is a big struggle, and we struggle with that as well, because you want to you remember what I mentioned about loyalty to your beneficiary. You still need to keep your beneficiary's interests first. But at the same time, as Richard mentioned, you can't afford to have your beneficiary homeless. One of the things that we do in a situation like that, Richard, is we review the parents' finances what other any potentials may be for one of the parents to get paid through the personal preference program for caring for that child, which will provide at least some income coming in. In some situations, if the parents are in between jobs, trustees may have an option to create a loan agreement. The trust will pay for certain expenses with the understanding that it gets repaid back to the trust. Because ultimately, we do still need to report to the state, and so we will question us on those distributions. But it is a struggle. I don't know if I've had an answer that would be 100% correct. I think that is one of the biggest challenges that we face as trustees in general. But you are correct, it is a struggle. Finding out resources, maybe there could be programs that reduce the cost of utilities, for example, for a family, or is there some sort of temporary rental assistance that family can access. So we have to go in the weeds when a situation like this happens. And if you don't have the expertise, it's probably best to get someone who does and pay for that out of the trust. And with the van, we get that challenge too. Now they're asking for families to contribute not only to the maintenance of the van, but even to the purchase. We have pushed back on that quite a bit. An idea is to have your family keep a lot of the travels. If there's another vehicle in the house, you can also report that and get proof of that from the family to show that this particular van is not the family van, that is primarily used for the transportation of that beneficiary. So anyway, moving forward to, and I'm sorry I probably didn't answer your question 100%.
It demonstrates that it's a challenge to be a trustee. It goes hand in hand with this because you have to set expectations for the families and the beneficiaries, and there is a pull. And you're fighting with the state of New Jersey all the time because they want to see what those distributions are beyond $5,000. You're struggling because you don't want your beneficiary to be homeless, and when the parent can't support their own child, you have to argue with the state to say, well, what would you like me to do? Would you like this child to be on the street? Because that's the reality of it. And you're as a trustee, maybe you're technically violating some of the regulations and you are indirectly benefiting other family members, but you have to be human and put a common sense to it. And I have this conversation with representatives of the state law. Tell me what you would like me to do. There is a human element to this, and it's not all just the rules that are written down. But that is the struggle. Because this is why picking the trustee is so hard, and why you get those calls about, I want this money, you're not doing what you're supposed to do. But by the way, there's a flip side. It is one of the most rewarding things to do when you're able to write the check out and pay for a family member to take a loved one to Disney World.
Absolutely.
And get those pictures back of them enjoying their time at Disney. So with the struggles comes the rewards and being able to enhance someone's life.
It really is. You're right, Richard. So quickly moving forward to selecting the trustee, these are some of the things that probably mostly families and well, even attorneys should consider. And you as a trustee should also keep in mind. So, I think I'm making this in one of my slides. Yes, thank you. So what experience does the trustee have in this type of administration? We talked about that other case that we had where the family member stepped in and supposedly was serving in the capacity of a trustee. A lot of families do pre-planning for a third-party trust to be funded in the future, and they want to name a family member as a trustee, which is a great idea. but be a little bit more thorough, ask questions. Know that this administration, again, is not just about the payment of the bill, it is about benefits. So that trustee that you select, even though third parties have less restrictions, I'm telling you right now that the Social Security Administration, Medicaid offices are getting very inquisitive about third-party trusts. They know that they cannot get a repayment, but they want to know what's going on with that money. What is the trustee doing? How are they doing those the distributions for that beneficiary? So get a trustee that has some expertise, and find out how many accounts do they manage for people with disabilities. It's not always just about knowing, but how many do you manage? Is it just one, two? The cases vary, so you want to have someone who is familiar with different situations. Total assets under management. I have seen trusts that require that a trustee have at least 20 million under management. If you're being approached to serve as a successor trustee to someone, maybe a family member who figures, this is too much for me, I cannot do this, sometimes we will see language like that. Someone can require only a bank, so you have to know that. How do you ensure the needs of the beneficiaries are being met? Well, one way is to get social services involved with regards to a case manager going out there doing an assessment for you. Maybe you do visits to that beneficiary. You also get to know your clients. Do a budget, find out what their life story is, their background. Don't just ask what bills do I pay for you. Does a beneficiary of a loan? Do they have children? All of that impacts how you can help that individual and what their needs are. How does a trustee provide proper communication? Can the beneficiaries call the office? Can they email? Obviously they send stuff by mail, but what else? Are there any other options for that, to make that better for that beneficiary? As I mentioned before, maybe just taking a picture of that receipt. Can a beneficiary use a credit card or a prepaid card? Yes, they can. I have many beneficiaries who live independently in the community. They have had their own credit cards for a while. They can use it to make certain purchases. We will review, again, what are the rules, what are the options that they have, and we will pay that credit card for them directly with the proper documentation. We also work with a company that provides a card that can be loaded by the trustee on a monthly basis based on a budget for certain expenses like gas in their car, maybe a haircut. Sometimes it's for vacation expenses. And you can actually monitor and you can block the merchants. So you're not completely out of control. And these cards are actually mentioned in the POMS, which is the Programs Operations Manual System of Social Security. So you know there's at least something that the Social Security Administration approves and is familiar with. How does the trustee keep informed of any changes? Do they belong to any trustee listserv? Do they keep in communication with maybe local attorneys who might know about changes in the law or propose changes to legislation that can keep you informed? Do you get notices or changes from Social Security directly? Are you listed? Do you have communication even with other trustees within your state? We say word of mouth. When we have a situation where we attend a conference or any event and it's mostly trustees, we walk out of there with the most ever, because they are your colleagues you know, you can relate. They understand to the core what your job is and what you do for clients. How often does your beneficiary receive statements? In our office, they receive them monthly. Our financial manager sends them out. And the statements just show what distributions have come out. Also be open to provide them with a transaction report, an accounting of what, if they have any questions, of what's been distributed. And what are the fees? You know, every one of us, this is our work. We all charge fees for the work that we do. And that's fine, but be transparent. Show your families and clients what your charges are, so there is no misunderstanding. And you don't get those phone calls, you never told me you were charging X for this. So that protects you also as an organization, as a corporate trustee, etc. And does the trustee have audits? In our case, as I mentioned, we're not under the banking regulations, but we actually do. We have 2 independent audits a year. One of those auditors is just for the trust department, and we get 3 audits a year from that particular department. So be able to show that somebody's watching. You also have in a lot of the trust documents a trust protector, which is someone who is appointed to oversee what is going on with the administration. They do not have a fiduciary responsibility, but they do have a right to ask you, you know, how is this being done for my family member? Or why did you pay for this for my family member? And in some cases, actually, in a lot of the trusts, they even have the power to remove and replace a trustee if they think that you're not performing to the standards of that trust. So be transparent with those individuals as well. And finally, what kind of insurance does that trustee carry? If something goes wrong, if there is a case of mismanagement of management or theft, is there any protection for your beneficiaries from that trustee? Every professional trustee should have sufficient coverage insurance for situations like that, whether they never occur or if they do occur. So I think that's the last of my slides.
So I just wanted to add one more resource. We do have a lot of materials on our website, plannj.org, but we also have podcasts. So we have a podcast about special needs trust administration. We have one on guardianship and on supported decision-making, which is a very important concept that isn't established legislatively yet, but we are hoping that you know, the community at large will help to move that needle. And there's mental health topics. There is a general estate planning on public benefits. So please, if you, you know, wherever you hear your podcasts, Apple Podcasts or Spotify, share that information if you would like more information or if you know people who would. Thank you so much, and we appreciate this opportunity.
Just to tie up a ribbon around that, one of the other challenges is how to pick a trustee. So when we see with people talking about supplemental needs trust or special needs trust, parents tend to say, "Oh, I'm going to have you know, my other child be trustee for their sibling," which sometimes is fine. I mean, sometimes if someone has more of a severe disability and they don't really need a lot of distribution, there's not really a lot of harm. When you have a situation with a very high functioning individual, maybe with some mental illness, and that person is asking for money every day, all day, multiple times a week, putting a sibling as a trustee of their other sibling, sometimes it's probably one of the worst decisions. But there's a tendency that parents want to kind of keep it within the family, and they don't realize some of the stress and tension that are going to be, it's going to be imposed on those siblings. And I think that's something to have a frank discussion when you're counseling individuals. And you have to really speak bluntly to people, because sometimes they underestimate and don't want to realize some of the challenges that are going to be faced. So.
Sometimes we see families also select a trustee or a successor trustee who's not a resident of New Jersey, it's difficult to do the administration in state. So I cannot even imagine what it is to do it out of state when you're not familiar with the processes here, regulations, etc.
Thank you again.
Thank you very much.
Okay. Okay, why don't we take a 5-minute break, and then when we come back, we'll talk about some advocacy and continuing the program. Let's try to keep it a tight 5. We'll come back and keep the program moving.